Hi, thank you very much for coming to listen to this presentation, and thank you also to the International Trades Council for inviting me to give you this note on intellectual property. Now, intellectual property is key for a startup, but key because it encapsulates a core portion of the value of a company. At the end of the day, you can go out there looking for partners, you can go out there looking for finance, but the question is going to be, do you own your ideas? Do you own the company? Well, you might own the company name, but do you own the underlying business concept? Do you own the underlying intellectual property? Now, protecting business concepts is difficult, but intellectual property gives you an angle where you can start to get some protection. So what I'm going to do, I'm just going to go a quick run through about options. The original presentation was mainly focused outside the US, and I'm a European attorney, so my practice covers really helping US companies protect outside the US, but I'll be a little bit more general. I was looking on the speakers list. There isn't direct coverage more generally, although I do recommend the presentation of my friend Adam Bialek, who is giving a presentation on intellectual property, more in terms of its web presence. So let's crack on. Why are we looking at intellectual property? Well, really, if you're a startup, it should be part of your DNA. If you're not encapsulating the goodwill of your name in terms of trademarks, then why are you spending the time advertising about your name, your product, your proposition, if you're not actually gathering the goodwill associated with that? Goodwill equals dollars, it equals value for the company. And so for that, you make sure that you get your trademarks and get a portfolio of domain names. Now, you also may wish to protect your logos. You've got copyright protection in the US, more generally throughout the rest of the world, although there's no registration there. So you need to have your finger on the pulse for these things. The key driver for setting company development goals, I think, should be, or at least should include intellectual property, because if what you develop is not going to be owned by you and owned by you exclusively as a monopoly right, the question is, why are you doing it? Well, maybe you're going to get first mover advantage, but are you the first mover? Is there somebody else out there, maybe in another jurisdiction, in another country? Well, that's your question to answer. Right, intellectual property. At the end of the day, it's a commercial tool. You know, lawyers like myself may enjoy playing with the law, but for yourself, really, if your intellectual property is not giving you a commercial benefit, you shouldn't be dealing with it. If you don't think that this presentation is going to give you commercial value, then switch off. Really, intellectual property law is complex. It's difficult to learn. You need an attorney to do it, but it is a key tool. And if you're not using that key tool, you should really ask yourself, why? Now, some pointers. Don't use a general lawyer. I'm sure your company will have a general legal advice, and good on you. That's great. You need somebody on tap. You need somebody who is close by, who knows your local jurisdiction. But most general lawyers are not hands-on with intellectual property. Now, for patents, you need a lawyer with a technical degree. If they don't have a technical degree, really, I wonder whether you should be dealing with them. Move on, find somebody else. And one of the reasons that I'm giving this presentation today is I'm giving it clearly and directly. This is my style. If you don't like it, fine. But if you do like it, maybe I'm the sort of person you'd want to work with. And that's the touchstone, really. Do you like the approach of the person? Because you can't untangle the background, their knowledge. You've just mostly got to take that on trust. So I'm coming along here today. I'm a qualified European patent attorney. I'm a chartered UK patent attorney. I'm qualified also as a litigator. No, those are my stamps. But the question is, when you're dealing with intellectual property, find a lawyer that you like, that you get on with. Okay, so the other thing to be aware of is that you need to get somebody who's got some familiarity with your area of work. Now, if for example, somebody came along to me and said, look, I've got music compositions, can you help me? I'd say, sorry guys, love to hear what you're making, but I'm not the guy. I'm a technology person. Horses for courses. if it's to do with manufacturing, if it's to do with electronics, chemicals, mechanical devices, even some pharma my colleagues deal with, then we can help you. But otherwise, no. So, find out what help you need. One of the other important points is lawyers, as you know, aren't able to deal with conflicting companies for companies which have very similar interests. And there's always the bind that you end up finding somebody who's ideal for you. But if they're ideal for you and any good, they're already working for somebody else in the same area. So be aware that you often need to educate the attorney. And basically, you also need to get on with them, because you don't want to spend your time educating somebody that you don't like. Right, okay, let's get some nitty gritty. You want to file a patent, budget $10,000. I'm sure you can get down on that. And depending on your technology area, you might get quite a long way down on that. But think of that as a ballpark, have that sort of budget available. And then £5,000 for additional jurisdiction. Now think about that. If you can capture the US for 10,000, well, why not capture the Europe for 5,000? You get twice the coverage, but for half the price. And that's one of the reasons that I'm here, to make you aware that there's a broader spectrum here. Now, you could say, look, Mark, I'm not interested in Europe. Fine. Then there's plenty of other attorneys in other jurisdictions. And if you need a recommendation, I can happily pass one on. No skin off my back. Great. Okay, so let's look a bit further. Intellectual property, trademarks and designs. Well, that is more of a sort of mainstream lawyerly work. And at the end of the day, it can often be fairly straightforward. The main point is get in there quickly. Now, if you've got a nice trade name, then make sure you register it now, and you register it in all your key jurisdictions now. Because, at the end of the day, we're talking about, say, $1,000 per jurisdiction. Well, okay, you might say, well, that's quite a bit. By the time I've totted up all the countries I'm interested in. But think of it this way. If you have to have a conflict with somebody else, it's going to cost you a good deal more than that. So, hey, sorry for the background noise there, if you can hear it. We're in a COVID lockdown, so let's hope that that's not any fallout from that. Okay, and there's also designs. Designs are quick and cheap, and if you want to build up your IP portfolio to show some evidence, for raising funds, for competition, for marketing, then that's a fairly straightforward one to raise some rights to increase your portfolio. Great, so let's think about more on the world stage. One of the key things, of course, is that intellectual property is about per jurisdiction. Now, one of the reasons that this presentation was originally not going to mention the US virtually at all was on the assumption that there might be a US attorney covering what I'm covering now, is that the rules are quite different per jurisdiction. I'm an expert for European countries, and I work with colleagues in other countries, but really it does change quite a bit. So you need that specialist local advice. And my apology if this presentation is looking a bit broad brush. You're thinking, Mark, come on, look, I want to get a bit more detail here. Well, if you want the detail, just drop me an email and I'll see what I can do to help you, because everything is per jurisdiction. There isn't a world patent. There's a process to get a world application, but that eventually dissolves to individual patents. And there is a good argument that in actual fact, you should always look from the beginning at individual countries. Because the last thing you want to find is that you've got a great trademark, for example, and you then find that somebody already owns it in Germany. That may really scup your chances in Europe, or, vice versa. So, okay, it's the economy. It's the economy. At the end of the day, there's no point in getting intellectual property rights in an economy which is going nowhere, which is not going to pay for your goods. But of course, then the question is, well, is that everything? Now then, everybody has their own opinion, but you can get intellectual property rights in China, and whether you can enforce those or not, well, okay, I'm sure you've got your own opinions. So you need to look at jurisdictions where the intellectual property rights are going to carry some respect. And at the end of the day, you've got a multiplication here. You've got the economy of the jurisdiction multiplied by the strength of the jurisdiction. And that really brings out two key jurisdictions for your intellectual property. There's a US and there's a Europe. And of course, depending on your particular business, there may well be other specific jurisdictions, and I don't do anything to undermine those other jurisdictions at all. But at the end of the day, you've actually got to look at those numbers. Right, so think about it. If you've got protection in the US, why haven't you got it in Europe? Maybe Japan, Korea, Australia, etc. If you're thinking, well, should I spend some money on China, Eurasia, South America, Africa? Well, maybe you should, but maybe that's the second tier. And at the end of the day, if you're trying to raise some cash, if you're actually looking about, well, what is a startup worth investing in? You need to ask yourself the question, what is the value of that intellectual property? And the value is by and large a multiple of the quality of the jurisdiction with the economy in that jurisdiction. Okay, so outside the US, the US as a jurisdiction is a little bit different. Trademarks, designs, in my view, are harder to get. You've got to show evidence of use of trademarks, whereas a lot of the rest of the world, you just say, hey, can I have the trademark? And that's good for you for maybe up to 5 years. Depends on the jurisdiction, bit of a broad brush expression, but that's a lot of it. So at the end of the day, if you've gone to all the hard work of getting things sorted out in the US, then extend to Europe, you know, just spend a few dollars and get it in the bag for the future. Work with US counsel. If you're a US company, you know, you need your US counsel. If you don't have somebody you can trust, that you can, that it's recommended to you, then drop me a line, I'll find somebody for you. I'm a director of an organization called AIPF, which is an association of intellectual property firms in the US, and I can give you referrals, and you can make up your own mind. Okay, so as I say, Europe. GDP of Europe, depending on how you count it, of course, is above the US. And so if you haven't captured Europe, then you probably should be clearly looking to do so. And if a company you're working with hasn't extended to Europe, really ask yourself why. Because, you know, why cut out, you know, something that could double your revenue? Okay, so patent counsel, how to make best use of patent counsel. I'll give you some top line numbers there. At the end of the day, don't think of intellectual property rights in those individual terms. Always think about them in terms of portfolios, because most patents, or many patents anyway, can be avoided. I've done quite a lot of work on, you may have heard this thing called graphene, which is a breakthrough, brand new piece of chemistry from a few years ago in a local area here in the UK. And, you know, within short sticks, there's been hundreds of patents on it. You know, nobody's got a monopoly on it. But what you do is you divide up your ideas, you divide up your particular USPs. And so maybe an opponent can, opposition, a competitor can avoid one patent, but can they avoid two? Can they avoid three? And by the time you've written one patent, or at least I have anyway, then often you can spin them out to additional patents with relatively limited cost. So that's one of the tools in your tool chest. The other thing to clearly notice, and it is in the US, but historically it wasn't quite the same, is first past the post. You know, you've got to get in there. The first one to file, the first one to apply for the legal rights wins. I got an email in yesterday, in actual fact for a friend from a property owning company, and somebody has been up there starting to use their name, but he got in there first. And at the end of the day, that makes him the winner. That gives us the legal upper hand in most situations. So don't hesitate. Just get out there, get those intellectual property rights. With patents, you've got a big advantage that you can apply for a patent today, and then you've got a year in which you can start to rework it and still keep what's called the original priority date. If you don't understand that concept, then that time it takes too long to explain it now. but you have got a bit of a window. With trademarks, well, the thing is, get in today and start building up that goodwill, because the longer you have it, the harder you work on it, the more it is worth. And the last thing you want to do is work up a lot of goodwill, a lot of ownership, a lot of possession of a name, and then only to find that somebody else owns it. You know, I got a call just a couple of weeks ago from a general lawyer, and he was saying, well, you know, my client would like to protect the trademark because they're going out there and they want to have a share flotation. I just looked it up, and it turned out that the trade name is owned by the Australian government. Well, now the Australian government was presumably not too bothered about the use of it, but you know, they're not going to be able to sell it for very much. They're not going to sell it at all because they don't own it. And they'd spent, you know, a few years as a startup pulling a lot of effort into their name, getting their name well known, a name which they have no value in ownership of at all. So they weren't too happy about that, but you know, better to find out later than too late. So just to reinforce the message, act quickly. And with designs, you also need to do the same thing. And at the end of the day, if you've got physical products, then, you know, take a photo of it, register the design. You've got some logos associated with a product, you know, register those. Plenty to be done. And one of the other key things that I'd like to mention is find patent counsel, a lawyer that you trust. Because what will then happen is you will then automatically have access to their extended network. You know, if you need somebody in the US, I can find somebody in the US. You know, other jurisdictions, you know, China, Japan, wherever. You know, those people I deal with all day, and I only deal with them because I trust them. And I'm not going to recommend anybody to them or them to anybody if I don't trust either side. So one of the things to bear in mind is that intellectual property is a bit of a punt. It is a bit of a gamble. If only about 30% of patents get granted, if quite a few trademarks get contested, then if you have just got a patent, a trademark, then really ask yourself, am I at a bit of a risk here? There was a very famous case in the UK. It was a design case related to a piece of carrying luggage for kids. You might have seen it. It basically looks a bit like an insect. And they had one design application, and they litigated it to heck. They really did. And the outcome was that for a few $100s more, they could have got a lot more design applications, had a little forest of them, and the competition would have had very, very little room to maneuver, and they would have avoided an awful lot of litigation. Get in there quick, get a portfolio, get on with it. And if you're trying to invest in a company and they don't have a portfolio of patents, or at least a patent strategy to get that portfolio, including obviously corresponding trademarks, for example, then ask your question, now, should we be investing in these guys? Have they got their act together? Okay, and if you're trying to raise capital or you're trying to sell company assets, then it's easier to sell two things for twice as much as it is to sell one thing. You know, if you've got a patent, which is the be all and end all, well, maybe it is, but why not have two? Because then, you know, you can always negotiate for a bit more. And often we're talking about multiples of a factor of 10, 20, you know, obviously we talk all sorts of silly numbers in terms of multiples of value. But the investment you put in intellectual property usually realizes a considerable factor, a multiple in terms of the cost versus the actual book value that you can put down for your company. Right, okay, so I've been a bit thin on detail, haven't I? Did I really go into detail of international patent applications? Did I talk about the WIPO, the World Intellectual Property Organization? Did I talk about the Patent Cooperation Treaty for international patent applications? Did I talk about the European Patent Convention and how you can cover up to 30 countries, in fact more than 30 countries, with a single patent application on similar equivalents in Eurasia, in South America? No, I didn't, because those are whole stories in themselves. And what I don't want to do is mislead you. What I want you to do is to make sure you've thought about these things and to point out perhaps the blindingly obvious. Get intellectual property now if you haven't already got it. Get more than one set of rights now if you haven't already got it, because more is worth more than fewer. Give yourself security. It's first past the post, so make sure you get in there. And it needn't necessarily cost a multiple to get a multiple of rights, because often there's overlap, and by the time the relationship has been established, for one set of rights, you've often got the groundwork for other. So there's my email. I'll do my very best to help with any questions you've got. You know, my key point is Europe, and behind me on the shelf there's a whole load of awards and accolades our company has got. We've processed more than 10,000 European patent applications. But your question might be for the US. Just fire it over. I'll see what I can do to help. So thank you very much. Thank you for your time, and look forward to speaking to you. I or a colleague will be available throughout the day, and contact me, and we can maybe even speak face-to-face online. So thanks for your help. Look forward to talking with you, and I hope this has been of some use. Thank you very much.